At stake is the question of the legal interpretation of comfortable satisfaction. WADA will assert that under CAS standard of comfortable satisfaction, circumstantial evidence is sufficient for a guilty verdict. The hearing was held in Sydney about a week or so ago. The decision has not been delivered, so we'll just have to wait and see. Once there's an anti-doping rule violation, we then move on to sanction. Sanction could include disqualification, which means the athlete results in a particular competition or event invalidated, with prizes, money, points are all forfeited. Athlete is barred on account of anti-doping rule violation. This would also prevent the athletes from training or even using the club facilities during this period of ineligibility. Provisional suspension, where the athlete is barred from temporarily participating in any competition pending a decision at a hearing. Financial consequences, which will include financial sanctions and public disclosure or public reporting. The period of ineligibility is 4 years for intentional cheats and 2 years for other kind of circumstances. The assessment is based on the degree of fault, which requires consideration of the particular circumstances leading up to anti-doping rule violation. It is a fact and case-specific exercise. The term intentional is used to identify the athletes who cheat. It requires the athlete or the person engaged in the conduct knew that they have violated or knew that there was a significant risk of violation and they have manifestly disregarded the risk. Once we have established that there is a violation and there's an ineligibility period that will apply, then we have to start looking into the defense, which essentially means how do we get the ineligibility period reduced. There are two key things that we need to talk about, which is no fault or negligence. Where there is no fault or negligence, there will not be any ineligibility period. Where there is no significant fault or negligence, the period of ineligibility will be reduced. Okay, but I need to caution that no fault or negligence will not apply in the following circumstances. Where there is a positive test from a mislabeled or contaminated vitamin or nutritional supplement, the athletes are responsible for what they ingest. The administration of prohibited substance by personnel or physicians or athletes, medical personnel without disclosure. This is also not an excuse. The athletes are responsible for their choice of medical personnel. Sabotage of athletes' food or drinks. Athletes are responsible for what they ingest and for the conduct of other persons whom they entrust access to their food and drinks. No fault or negligence means that the athlete or persons establishing that he or she did not know or suspect could not reasonably have known or suspected, even with the exercise of utmost caution. Utmost caution has been delivered in the opinion by CAS, and they have set out a few examples, which include that the athletes have to be aware of the actual list of prohibited substance. They have to follow closely the healthcare guidelines. They are not to take drugs, not to take any medication without advice of the competent medical professional. The CAS panel, in fact, underlines that this is a very rigorous standard, especially in the interest of all other competitors in a fair competition. But the panel reminds that in trying to achieve these standards, one should not lead to unrealistic and impractical expectations. And to assess the degree of negligence, we have to look at the test, the objective test and the subjective test. The objective test would be what standard of care could have been expected from a reasonable person in the situation of the athlete. Would he have read the product label, whether he has cross-checked the ingredients on the label, whether he's done search on the product, whether the product is reliably secured, which means that whether the bottle is sealed, whether the seal has been tampered with, and whether they have consulted with experts, especially the nutritionists, the physicians, on the safety of that product itself. And the subjective test, would be what could have been expected from the particular athlete in light of his personal capabilities. Okay, some of the examples from CAS, some of the cases. One of the cases would be ITF against KLRCA, where the athlete has ingested a small amount of cocaine from kissing a stranger. CAS held that he could not reasonably have suspected he could be contaminated in that manner without fault or negligence. And the other case that I have is Daryl Impey. The facts were that the gelatin capsule were contaminated after it was being packed by the pharmacist. Evidence was presented as to the athlete's knowledge of doping, extensive commitment to anti-doping, and whether he has acted due care in those doping matters. The panel was of the opinion that to have expected the athlete to have considered the possibility that the gelatin capsules may have been contaminated would constitute an unrealistic and impractical expectation. So with that, the panel has also ruled that the athletes were of no fault or negligence. But contrary to the recent case of BWF against Dato' Lee Chong-Wei, similarly, the gelatin capsule was also contaminated and he was handed an 8-month suspension, which is backdated to the sample collection date. Okay. Once we determine that there is ineligibility period that will apply, and we will try to reduce it. Once that is done, then we have to deal with the commencement of the ineligibility period. The period will start from the final decision hearing, providing for ineligibility, or if there's no hearing or the hearing is waived, the date ineligibility is accepted or imposed. Unless there have been delay on the part of the panel to delay the proceedings, or the athletes admits to violation, or there has been a provisional suspension, then the ineligibility period can be backdated to the sample collection date. So as you can see, the main questions to be assessed in this whole scheme of things is that when you take into account doping, anti-doping rule violation, first question that we need to ask is that did the athlete establish how the substance entered into his system or entered into his body? And if he's able to convince the panel on how this substance entered into his body, does he in such circumstances bear no fault or negligence, or no significant fault or significant negligence? Once that has been done, then the panel will consider the period of ineligibility. After the panel has handed over the ruling, then you have 21 days to make an appeal to CAS, and WADA has 21 days from the date of receipt of decision to make an appeal. Okay, just a little bit on something on endorsement, because doping doesn't quite go very well with image rights and sponsorship. In fact, doping is the downfall of every athlete. So when we deal with commercial contracts and all that, it is very common that the sponsors would always include a clause on violation of anti-doping rules, or even to a wider extent, engage in any immoral acts. So when this happens, the sponsors will have the right to terminate the contract, and to a certain extent, there will also be compensation which the athletes have to pay the sponsors for breaching the terms of the endorsement contracts. So that basically sums up what I need to deliver today, and thank you everyone.
Okay, can you remain on stage? I invite you to the top over there. I'd like to invite Nishel as well on stage.